Morning, Judge. Joseph Chu, 11082 for the plaintiffs.
Good morning, Your Honor. Paterno Jurani for Zaon Collins.
One, Your Honor, Abe Smith, and for Marvin Collins, we also have Brad Johnson and Lord Wigginton for Collins.
Sasha Araujo also for Marvin Collins. Sasha Araujo, bar number 16675. Thank you.
Everybody just take a seat. Did we get everybody on? Mr. Johnson, did you make an appearance? I know I heard you say anything.
Yes, Your Honor. Good morning. Brad Johnson on behalf of Marvin Collins. Thank you.
Okay, so this is the time and date set for the motion to amend answer. Thank you, everybody, for being here today. I believe you guys have submitted a stipulation regarding the motion to retax costs, correct?
Yes, Judge.
So if that is essentially resolved, I will not hear that today. If anybody wants, does anyone want to make any kind of record regarding?
Not from plaintiffs, Judge.
Let's talk about the motion to amend answer. Mr. Jurani, you're the only one here for Zaon Collins, right?
Sorry, Your Honor, I'm having a little trouble hearing you.
Are you the only one here for Zaon Collins?
I believe so, Your Honor.
Okay, so why don't you go ahead and start?
Yes, Your Honor. This is our motion based on NRCP 15B1. We're requesting to amend the answer to include the comparative negligence defense. As you know, Your Honor, 15B1, we believe the two requirements are met. It will aid in presenting the merits. Also, the plaintiffs are unable to show any prejudice that will result. Our motion included numerous examples of plaintiffs being informed and aware that we were alleging an affirmative defense of comparative negligence, including responses to discovery back in 2024 and arguably all the way back in 2022. Plaintiffs questioning Zaon Collins in his deposition regarding that, regarding the left turn made by Mr. Echevarria. Additionally, Your Honor, counsel for plaintiffs, Mr. Latta, made comments during trial, in fact, saying he was not even aware that the affirmative defense was not pled. As you know, they didn't bring up the issue until May 9th, which was, I believe, the second day of actual trial, and before any evidence had been heard, only the openings. Your Honor, pursuant to Grouse, you know, this matter has been brought up, it's been heard. The language they use is raised and tried. I don't even believe the plaintiffs in their opposition addressed any of the numerous examples we provided, and you know, I suspect the court does not want me to go through every example in detail of where plaintiffs were informed and indicated that they were aware that we were alleging the comparative negligence defense, but they didn't even address that in their opposition, Your Honor. They mostly argued they didn't consent. Your Honor, I don't see any reason why. This is a clear-cut case to me, Your Honor, but unless you have questions, I'll leave it at that. I know the court has read all the briefings.
I would actually like you to address the ethical concern plaintiff's counsel brought up, specifically in Mr. Latta's declaration, paragraph 8, page 2. In a declaration dated April 23rd, 2025, defense counsel Stephanie Zena stated, "I've done everything in my power to streamline this trial to attempt to make this date work, including admitting liability as to Zaon Collins and stipulating to multiple exhibits. I will posit to the court that 3 weeks is unnecessary for the length of trial regardless, which may aid in resetting it sooner." Can you respond to that a little bit? Because look, there's a couple instances during this trial where ethical concerns have been brought up by plaintiff's counsel, and this is another one, and this is concerning to the court. So what is your position on this, and how do you respond to this?
Your Honor, if I'm understanding you correctly, those were discussions with regard to a possible stipulation as to liability. As you know, no stipulation was ever reached. There was never, the defendants never at any point said that we completely agree. It was always we need approval from the insurance, or we needed approval from the client. I think that's a red herring, Your Honor. Clearly, they were aware of our defense of comparative negligence. They were the ones that prepared jury instructions, regarding the same. It's just, Your Honor. I mean, that was surely in. I believe that quote was from pretrial preparations, pretrial hearings. We cited numerous examples from a year, 2 years before trial where they were aware of this defense. They even retained an expert and submitted a report. I forget the date, certainly well before the trial. There's just no prejudice here, Your Honor.
But how is this unclear or vague, including admitting liability to Zaon Collins? Like, if you are admitting liability, what notice are they on that you're gonna assert a comparative negligence issue?
Your Honor, as I said, they prepared for the issue. They obtained an expert to argue the issue. They prepared a report which explicitly addressed Mr. Echevarria's left turn and the speed of Mr. Collins. Those were discussions that were, a proposed stipulation was had, but no agreement was ever reached. There's no indication that they did not prepare for the comparative negligence defense. In fact, as I said, even in trial, Mr. Latta said himself that he was not aware that was not even pled. So clearly it demonstrates the understanding that they were aware that we were arguing that affirmative defense.
Okay. Is Miss Zena in another courtroom right now?
No, Your Honor, she's recovering from surgery.
Okay. Because concerning to the court as well, there was a rumor she went on a 3-week vacation to Europe after this trial. Did that occur?
She did have a vacation, Your Honor.
Okay, or she got on a plane to Europe after this trial?
Yes, Your Honor. I don't know the relevance of that, but yes, she did go. She did have a vacation.
Well, the allegations that were made earlier in this case were of a pretty serious condition that I don't know would have been wise to get on a plane if that was really the case. So I'm concerned. And especially with some of the statements that now are being presented from plaintiff's counsel and how we move forward here. So, okay. Anything else, Mr. Jurani, before I see if any of the counsel in the courtroom want to add to this before I hear from plaintiff's counsel?
I would only briefly add that Ms. Zena also represented to the court numerous times that her condition, she had a note from the doctor that she was able to continue with the trial. While her condition was extremely serious, accommodations were made so that we could proceed with the trial, and she didn't have to cancel a vacation, Your Honor.
Okay, it's just, like I said, it's alarming to the court when somebody says they can't try a case, but they can go on a multi-week European vacation. Okay? If that's in fact what occurred. And I don't know exactly what occurred, but like I said, that's been the rumor. So that's alarming to the court. And then in light of this, where counsel's actually pulled a statement saying that there was an agreement to admit to liability, or at least a proposal to admit to liability, and then a very about-face behavior at the trial where now there was a comparative negligence claim. And yeah, I did let this go to the jury, and I let this go to the jury because the harm of not letting it go would have resulted in potentially another trial if I didn't let it go. It did ultimately come back that the jury didn't find any comparative negligence here, but some of the allegations made here and some of the facts and history is concerning to the court in light of what we're talking about. So anything else?
Your Honor, if I may, I believe that proposed agreement happened at the earliest in February, which we initially thought we had a March trial date. This was not something that impacted any discovery that was done. I don't see that creates any prejudice.
Okay, I'll let plaintiff's counsel add to that too, or respond to that in just a minute. Mr. Smith or Ms., I'm sorry, I don't know your.
Araujo, it's,
Either one of you all want to add anything to this, don't stand, just pull the mic close to you. Just because if you stand, the chances of having an issue with anybody online hearing you are greater.
Thank you, Your Honor. And I apologize, my instinct is to stand for the court, but I will do as you
Excuse me.
prefer. And I do want to make sure I'm addressing your concerns, and I heard you focusing on the declaration from Ms. Zinna. I would suggest that if Your Honor is concerned about any kind of rumors that Ms. Zinna have an opportunity to respond to that before the court issues a ruling based on those
I
rumors.
haven't precluded anybody from being present today.
Well, Your Honor, as Mr. Jurani stated, Ms. Zinna is recovering from surgery now. My understanding, again, I'm not a doctor, but my understanding is that the issues with the trial date had to do with her being on particular medications in preparation for the surgery, and that
Mr. Smith, what day did you come into this case?
uh
Because I didn't see the trial at all.
I was
actually,
not
if
at the
I remember
trial.
correctly. Okay, so I appreciate what you're doing right now, but I don't know if it's totally appropriate. So if you want to respond to things that you weren't present for, I guess you can, but just do it with caution, okay? Because you're going to be held to what the record says. And if you misstate something, that's going to be taken very seriously by this court. Understood?
I 100% understand, Your Honor, and I agree with you. I mean, we should be
Everybody needs to be candid with the court, and everybody needs to be honest here. And if somebody's going to allege that they can't do something, they should not be able to actually do it. Otherwise, it's concerning to the court. And then some of these statements here that are brought up by plaintiff's counsel are concerning to the court. Some of the things that happened during the trial were addressed by the court. I understand you were not present for that, sir, but I implore you, review the record, okay?
Absolutely, Your Honor. And I mean, and I was going to say, I mean, Mr. Chu and I have been against each other a number of times. You know, I didn't think this our motion was quite as contentious as the one that came before us. I've always found Mr. Chu to be very professional, and I've tried to extend the same courtesy to him. I didn't see in their opposition an accusation under Rule 3.3 that there was some failure to be candid to the tribunal. I understood it as them saying that, look, there was this position taken, and therefore, you know, we should not have had to try the comparative negligence defense at trial.
Okay.
So I understand what Your Honor is saying about the record. Yes, I was not at trial. I'll admit that. But I'm also concerned that if Your Honor is considering issuing some kind of ruling based on what Ms. Zinna can or can't do, that be explicit and that we have an opportunity to respond to that, because I didn't understand that to be the basis of plaintiff's opposition.
Okay.
Um,
Anything else?
Well, yes, Your Honor, I did want to just make sure we were all clear about our position vis-a-vis number one, Marvin and Zaon, and then also why we're still asking for this relief, notwithstanding that the jury
Yeah.
came back with 0% negligence. So on the latter question, is our position clear on why it would be important to have a ruling from the court on this issue? I'll just say that, you know, when this goes up on appeal to the Supreme Court, they're going to be looking at this record. They're going to be looking at any errors, you know, or unless there is a new trial granted. But if Your Honor doesn't grant a new trial, if we go on appeal, the Supreme Court's going to have to review these issues, and they're going to have to say, well, was this harmless error, or was this prejudicial error? Part of that analysis is going to have to do with what are the issues in the case and whether or not the court granted leave to amend the answer to have comparative negligence is one of the issues. So I think it is important.
Comparative negligence did ultimately go to the jury in this case.
Correct. I mean, and I think that is something that distinguishes this case from the State versus Sutton case that you were talking about earlier, for example. So that case, you know, the parties, the community college system belatedly asserted that plaintiff, their professor that was up for tenure, that he had waived his right to complain about the time period that had elapsed between his initial evaluations and the hearing. But that defense wasn't raised. And in fact, the Supreme Court rejected it as a matter of law on the merits, saying that the community college's code prohibited a waiver. Nonetheless, it ended up being a moot point because the issue did not go to the jury, and the Supreme Court was evaluating it from the stance of, well, did they need to order a new trial on that basis for the defense to go to the jury?
Yeah.
And again, I do think the fact that the jury found in plaintiff's favor on this issue underscores the absence of prejudice. Now, yes, we do think that there were errors in how we got there, but certainly they weren't. There wasn't an inability to mount a defense to this, or sorry, a response to this comparative negligence defense. So I really don't think that the plaintiffs can argue that the prejudice was enough to overcome the presumption under 15b1 that the amendment should be freely given. And I understand what they're saying about Rule 8C, which, by the way, is different from the waiver rule under Rule 12H. I mean, there it is very specific that if you don't raise this certain 12B defense or 19B defense at certain points in the case, then those defenses are just gone, right? Whereas 8C doesn't have that waiver language, and instead we have 15b1 that does reverse the presumption and say, that unless the plaintiff can or the party opposing amendment can demonstrate prejudice, that amendment should be freely given.
Okay. Response.
Thank you, Judge.
And here's what I need to hear from you, because memory serves, and I'm not going to say I allowed this in the first day. I think you are correct that this was brought up on like midway through the trial, maybe even more than midway through. Like at the 12th day is, I think, what you stated in your moving papers, and I think that might be correct. But I do think that we had not completed all of the expert testimony so that you could actually offer evidence responding to this affirmative defense. But if I am wrong, I would like to hear that from you. Or if you don't agree with that, I would like to hear that.
Yeah, Judge, just to address that point, the motion to amend the answer to add in the affirmative defense of comparative negligence was filed by the defense on the 12th day of trial. So that much is true. The issue itself, however, was raised by Mr. Latta and myself the day of opening statements. And if the court needs us to supplement the record to that effect, we can. But it is from the in the reply brief where the defendants have the back and forth from the court, where Mr. Latta does candidly concede that he had not prior thereto been aware specifically of the absence of that affirmative defense. It tailed from that discussion where this issue was raised for the first time. And the reason we did raise it at that point was because if you look at the case law which addresses this issue, one of the reasons why the Nevada Supreme Court upheld the permission of a otherwise late amendment to pleadings was because these matters had been raised in opening statements and throughout trial without objection from the opposing party. And that certainly wasn't the case here. That's why we brought it up before opening statements. And Your Honor, if I can with the presence of appellate counsel here, it sounds like this is going to be an issue that comes up in some capacity or another. If I can just briefly touch on the procedural, the sequence of events here. They filed their answer December 29th, 2021. An answer to the amended complaint, November 17th of 2023. So 23 months apart. Neither of those two answers contained an affirmative defense of comparative negligence. The second answer, though, did add an additional affirmative defense. So it's not like it was just a complete cookie cutter, templated assertion. They did take time to add additional affirmative defenses, comparative negligence was not one of them. We have 3 years of litigation essentially thereafter. Some of that was stayed because of the criminal component of the case, but extensive discovery, I believe 2+ years. There was no discovery whatsoever done by the defense on the comparative issue. They did not retain an expert witness in the field of accident reconstruction or anything remotely similar. They did not depose our accident reconstructionist. They propounded no written discovery or took no depositions geared toward establishing comparative fault or even exploring that issue. We had 2 separate 2.67 conferences with defense counsel, which were transcribed and were attached through various matters throughout the course of the trial. Those were in February and March of 2025. This issue was not raised at that point. The defendant's portion of the joint pretrial memo did not reference comparative negligence as an affirmative defense they intended to assert during trial. Then we have this lead up in the few months before trial where we are going back and forth with counsel about a stipulation to try to streamline the trial issues. And one of those was conceding liability, identifying Zaon Collins as bearing 100% responsibility for the collision. And in the course of those back and forth interaction is when Ms. Zinna took over for former counsel from the same firm, where the statement that Your Honor referenced at the beginning of this, where she says that she's done everything in her power to streamline this trial to attempt to make the state work, including admitting liability. That's where that statement fell. So at that point, Judge, it was extremely unclear, and there was considerable uncertainty as to whether liability was going to be conceded, and specifically whether comparative fault was even going to be raised at trial. And ultimately, as Your Honor noted, the jury came back and gave us a $15 million verdict and assigned 100% liability to the defendant and 0% to Mr. Echevarria. So in that sense, it feels like the issue is kind of moot. However, if we're talking about prejudice, we have to go back to what the prejudice was at the time that this issue was raised. And we can start with, we were certainly prejudiced in terms of how we prepared for trial when we do not know whether the issue of comparative or even liability is going to be conceded at all. And we have this carrot on a stick dangling in front of us about, well, yeah, we're trying to get to a point where we can stipulate on these issues. We're not quite there yet. And we're just in the weeks and days before trial. It's certainly going to affect how we prepare our own opening statement, how we prepare our own witnesses for testimony, how we prepare our cross-examination of the defendants. We didn't learn that comparative was going to be argued until literally the day of opening statements, when we kind of brought this up as a precaution, only to learn that, yes, in fact, this was going to be a central issue of their defense. It also created a path for the defense to ask for what amounted to complete exoneration from the damages. I mean, if you recall, Judge, Ms. Zinna asked for 50% comparative to be assigned to our client, and Mr. Johnson asked for 51% comparative to be assigned to our client. That was otherwise not an option had this issue not been raised, again, on the 12th day of trial. And if we just look briefly at the limited case law on this subject, in the instances where the Nevada Supreme Court has upheld the late amendment to pleadings in relatively comparable situations, the distinctions are, and I'm referring to page 6 of our opposition, the Elliott versus Resnick case, as well as the Schwartz v. Schwartz case. In those instances, the court found that there was trial by consent where the issue had been explored in discovery, and after the issue was raised in opening statement and evidence was introduced throughout trial, there was no objection to those items by the opposing party. And I think a better comparison, Judge, is in the
I don't find it consensus if there's any worry on that.
Okay, I appreciate that, Judge.
Shortly after the opening statements, I believe you all did bring this up. I don't think the motion immediately followed. The motion was shortly thereafter, but I don't find that there was consent here, if that's the concern. You voiced the issue shortly after opening. I do recall that. And I think I asked you all to brief it. And so we try to find time to hear it.
You're correct, Judge. And it was a matter of finding time amidst all the other items going on. The last thing I want to,
The desire to, there, on the defense request, there was a desire to speed this trial up, I thought, because there was a hard date that defense counsel was no longer available, which I thought at the time was for a medical procedure that was going to be had at that time. At some point during the trial, I believe we were informed that that hard date no longer existed, and it was fine to, I don't want to say take our time, but that we had more leeway than we had originally thought. I'm speaking from memory here, and if I'm wrong, you were there present the whole time, counsel. Mr. Jurani, you were as well present. So if anybody thinks I'm wrong, Mr. Johnson, I believe you're present for most of the trial as well. Now's the time to speak up.
Judge, I think you're correct. I don't think that Ms. Sinna's medical needs became the reason to need to finish trial. I believe she had pushed everything out. I believe the issue was there were one or two jurors who had specific travel plans or something to that effect, which gave us 15 or 17 full days. In either event, I believe we finished just in time with a day or two to spare. Judge, the State versus Sutton case, which Your Honor mentioned in the previous hearing, and which Mr. Smith just mentioned in his argument. In that case, UNLV wanted to add a waiver as an affirmative defense after the close of evidence and when they were arguing jury instructions. And they argued that they actually raised this issue much earlier in the case in opposition to a motion for summary judgment, and that they had an estoppel affirmative defense, which was timely pleaded and which was principally consistent with waiver. And they also argued that the evidence that was presented about waiver at trial was without objection from the plaintiff in that case. The court denied that motion, and the Supreme Court upheld that denial. And the court found that the motion to amend, or the denial of the motion to amend, was supported by, one, the untimeliness. Again, this was on the 12th day of trial in a case that was originally filed in 2021. Two, the fact that the waiver defense sought for inclusion went to the heart of Sutton's claim. And three, the fact that the defense asserts matters that clearly were within UNLV's knowledge at least 9 months before trial. Again, the motion was clearly untimely, 12th day of trial. The waiver defense, the affirmative defense of comparative negligence certainly went to the heart of our claim. It allowed the defense to ask for what amounted to a defense verdict in the case. And lastly, obviously all the facts that would have given rise to at least a colorable affirmative defense of comparative negligence were within the defendant's knowledge, not just 9 months before trial, as was the case in Sutton, but going back to the date of the accident in 2020. So years before. And unlike UNLV, they did not raise comparative fault in any prior motion. They did not assert any other affirmative defense remotely similar to comparative fault. And certainly any evidence of comparative fault offered at trial was met with objection by our side of the courtroom, judge, unlike what happened in Sutton. And even then, the court still rejected the request to amend the pleadings. And as Your Honor noted, it was in Sutton where the Nevada Supreme Court appropriately noted that the liberal policy provided in Rule 15A does not mean the absence of all restraint. So while we agree that the standard to amend pleadings is a liberal one, it doesn't mean it is without its limitations. And we feel that here it would be appropriate to deny the motion, which we think is futile anyway, as evidenced by the jury's verdict of assigning 100% fault to the defendants.
hear where I'm at, and then I'll let you talk if you want to talk again. Okay?
You're gonna ask Mr. Jurani to go first?
Oh, yeah, sorry, I was looking at you, but the same thing. Mr. Jurani, why don't, I just want you to hang out for a minute. I'm gonna tell you where I'm at, and then if you guys feel like you need to talk, I'll let you talk, okay?
Thank you, Your Honor.
But I don't know if I need to hear from you guys again. However, I'm not trying to preclude you from making whatever record you want to make. So here's my thoughts. Looking at Sutton, and I'm going to read what I read in the last case that had the same issue in front of me, but the liberal policy provided in Rule 15A does not mean the absence of all restraint, or that the intention, and I'm reading right from Sutton, 120 Nevada, 972, 2004. Again, I'm going to start. The liberal policy provided in Rule 15A does not mean the absence of all restraint, or that the intention leave of court would not be required. The requirement of judicial approval suggests that there are instances where leave should not be granted. Okay, Sutton ultimately concluded that the district court did not abuse its discretion in denying UNLV's motion to amend. In this situation, I allowed this issue to go to the jury, and now I'm looking at the motion to amend post-trial, and I understand the argument might be futile because of how the jury ruled, but I think it's actually a big benefit that we have of how the jury ruled, because I think what we're seeing is that there was no evidence of prejudice. I know you're trying to argue there is, but I think we're seeing there was no evidence of prejudice because the jury came back and found in your client's favor. Okay. We're not always in that situation where we get basically to look back and see what happened. I'm also going to distinguish it from Sutton, or I distinguish it from Sutton in my mind, because this isn't a situation where we were arguing over jury instructions and this came up for the first time where evidence was closed, but it came up during opening statements. Okay. And I believe, like I said, I think we made record earlier, but my memory serves as well that plaintiff's counsel brought up for the first time shortly after opening statements, which tells me you were on notice, you had the ability to put on evidence. This was a left turn case. So I'm not saying there's an automatic assumption that this is going to be an affirmative defense, but at the same time, it's a left turn case. I think you had the ability to put on the evidence that you needed to put on, and I think the verdict ultimately shows you had the ability to put on the evidence you ultimately needed to put on in order for you to not be caught in a situation where you were overly prejudiced by this. So I'm going to grant your request to amend both Mr. Jurani, both for Zaon Collins and Marvin Collins. Do you guys, let me talk first with Mr. Jurani. Based on the fact that I'm going to grant it, and I like one of you guys to draft the order, where I said, maybe you can put it more eloquently than what I'm saying right now. I'm sorry, I'm really not feeling well today. But I'm trying to be as clear as I can on the record, and I didn't want to take this one under advisement too, because I knew, well, after I heard argument, I was pretty sure where I was going to go, and I don't think there's benefit to delaying this case further if we don't absolutely have to. But I do distinguish it from Sutton because we had the whole trial to go forward essentially with knowledge that this was a possibility, and you were able to put on evidence. And I think the verdict shows that you were able to put on evidence to refute this affirmative defense. So any questions? Let's start first with Mr. Jurani about my ruling today. Or do you want to make an additional record? I'm sorry, Mr. Jurani?
I don't think I have anything else. Thank you.
Okay. Mr. Smith or Mr. Johnson, whoever wants any additional comments or any questions.
If you don't mind, Your Honor, I do have a couple comments first.
Sure.
I want to thank Mr. Chu for his candor and what you mentioned earlier about the statement that they weren't aware that this hadn't been alleged as an affirmative defense. So I appreciate the candor there. And just to be fair to everybody, since if we're going to be drafting the order, I don't want to be shoving a bunch of things in there that nobody's heard before. I think another basis on which to distinguish Sutton would be the fact that because the district court denied the motion to amend and also denied the jury instruction, the consequence of the Supreme Court finding that amendment should have been given to amend would have been to automatically award a new trial. And here, because we have the record of the defense actually going to the jury, us being allowed to amend the defense doesn't in itself, warrant a new trial. So we would still have to show to the Supreme Court, in any, or to this court in any motion for new trial, that there was prejudicial error from, relating to that affirmative defense. And I think that's another basis to distinguish that.
I'm fine with that being in the order. Mr. Chu, do you have any issue with that being in the order? I mean, we ultimately get to the same result. And as I said, I think the verdict shows that you were able to respond to the affirmative defense. And quite frankly, the jury seems to find that you responded quite effectively. So I am hard pressed now to find that there was prejudice to you, even though I know you're asking me to do so.
Respect the court's ruling. A little.
Don't have to agree with it.
No, it's fine, Judge. It's a precarious spot looking back and kind of arguing this in retrospect, but
Have the benefit of the situation.
yeah, and I'll ask for the point Mr. Smith just mentioned. I mean, I guess draft it up, include the language, and maybe the concept will make more sense to me at that point. Your Honor, there was one housekeeping matter we wanted to bring up if we can, or
Yeah.
okay. And I had sent over a stipulation to Abe this morning, but figured we would just bring it up now. We can still submit the stipulation as needed. There were two motions filed by counsel for Marvin Collins, so by Mr. Smith in his office. One was a motion for a new trial, and one was a motion for judgment as a matter of law, I believe as it relates to the family purpose doctrine. Is that right? We are submitting a stipulation, or we've stipulated to extend the briefing schedule out by 2 weeks. Originally, the opposition date was scheduled for tomorrow. We're pushing that out 14 days. I believe the hearing was scheduled for the 5th. And we're essentially asking that be pushed back. We're giving 2 weeks for the defendants to draft their reply. And then at any point thereafter that the court wants to set the hearing, then it's free to do
I
so.
guess the question would be, do you have availability? We could propose possibly the 20th, if Your Honor has availability then.
Yeah, I can put you on at 10 o'clock on the 20th.
Okay,
I might have a settlement conference, but I can push it.
so then our reply would do, their opposition is due the 30th, our reply would do August 13th.
As long as I have your documents a couple days before, I should be able to get through them. So as long as you can get me all of your pleadings by well, let's say the 15th. Okay,
The
just in
courtesy
case.
copies? Or
Courtesy copies are great. I appreciated the binder, especially with the tags, but I also know that maybe we don't always have time to do that. And if we don't have time to do that, as long as you got everything filed by the 15th, my office can print it out. So if you get them, if you can do courtesy copies by the 15th, great. Appreciate that. But as long as they're filed, everything's filed by the 15th, that's great. If you can't file everything, 15th is fine. Yeah, as long as you feel like that's gonna be enough time for you to read and prepare.
That's fine, Judge. Absolutely. Yeah.
I'm okay with pushing past look, if you two are in agreement and you're going to show up, okay, I'm not trying to be facetious with that. I can agree to almost any day. We have hearings 5 days a week in here. And most mornings it's either 9:45 or 10 o'clock, and we have a couple afternoons too, but I would kind of suggest veer away from the afternoons because that either tends to be people who want special settings unless you are by yourself, or tends to be some stuff that goes lengthy. So 20th is fine. Send me over the SIP. I'll sign it. Take your time getting it. Right now we'll tentatively think that the 5th is probably not going to go forward. Okay.
Excellent. Thank you, Judge.
Thank you guys very much. Maybe Mr. Jurani does the first draft of that order and you revise it so that, because Mr. Jurani, I think, was present for the whole trial, if memory serves, right? Mr. Jurani, you were there.
Correct, Your Honor.
Okay. Maybe he does the first draft, sends it to you, and then you get it to Mr. Chu.
We will for sure work that out.
Your Honor, I had one question.
Sure, Mr. Johnson.
Did we have that motion for retax on for today or not? I know there was a stipulation. I just didn't want that to pass by.
I thought the stipulation actually said that you guys wanted the hearing vacated. No, or maybe I wrote on it vacated. For some reason, I thought that was vacated today. Am I incorrect? But I appreciate you bringing it to the court's attention, Mr. Johnson.
Thank you, Your Honor.
It did, Your Honor, and that the order entering the stipulation regarding costs was the NEO was filed on July 1st.
Okay.
Mr.
So,
Johnson was afraid I was going to make him argue that.
It was his to argue. I will set I'll set an in-chamber status check for the order for the 29th. That gives you guys 2 weeks from today. Does that anybody think that won't be enough time?
It's fine by us, Judge.
If there's gonna be competing, right in the signature line, could not agree, they'll submit a competing for their signature. But, if you guys are working well together, I appreciate it. Okay, thanks for being here. Have a
Thanks,
good day
Judge.
and a good afternoon.